Okay, it's about 1:30. Can we resume, Mr. Pofu, Mr. Tengo? Your teams are back and ready?
Yes, my lord.
Okay, good.
We're back on our side.
Okay. Good. Mr. Tengo, for you ready? We can kick off?
Yes, we are, my lord.
Good, good. And both Judge Weiner and Judge Malheshli are with us, correct? Yes, thank you. Okay, Mr. Mpofu, court resumes, and you're going to give us some feedback just on some logistics, yes?
Yes, thank you, my lord. My lord, and my lords and my lady, we have had a discussion on compensation. This is a proposal which is close to what we have agreed. That we have between now and the end of today, we have 2.5 hours, and we will endeavor to finish in that time. We would ask for the court's indulgence if there's a little bit of a spillover. Because the idea is to finish the applicant's case in, let's say, 2.5 hours, or give or take a little bit if the court is so minded. If the court is not so minded, then of course it's 2.5 hours. Then the other side would take not more than 3 hours, because we are taking into account the amount of time that was spent by Ms. Kofa. To account the amount of time that was spent by Ms. Kofa, 2.5 plus that's half an hour or so, then it's a total of 3. Then they would have up to that amount of time for tomorrow, and then the reply we haven't allocated the time, but obviously it will be within reasonable bounds. But it would seem that on either version, we will be able to finish comfortably on time tomorrow. The only reason that I'm asking for the indulgence of the court is that if it so happens that I need even 20 minutes or whatever, I would just beg the court that I have that today, rather than having to do another little bit tomorrow. But I can give the court the undertaking that I will try to finish within the time. So if it works like that, then they will have the equivalent amount, and then we'll reply. So that's the broad plan. As the court, please.
Okay, good. Mr. Trengrove, that proposal was discussed with you, and you're in principle okay with that?
Indeed, my lord. May I just say that I agree with my learned friend's principle, but not his arithmetic. They've already had 1 hour. They get another 2.5 this afternoon. That would be 3.5, and we will then take 3.5 tomorrow. They get another 2.5 this afternoon. I would also suggest my 3.5. I support my. And we will then take 3.5 tomorrow. That he be allowed 2.5. I would also suggest my 3.5. I support my. We will then take 3.5 tomorrow. That he be allowed 2.5. I would also suggest my 3.5. I support my. We will then take 3.5 tomorrow. That he be allowed 2.5. I would also suggest my.
That's an endeavor with a capital E, so that if we run past 4, it would not be significantly past 4. And then we might just want to decide that we start at sort of 9:30 again tomorrow morning.
Yes, yes.
So that we can, we'll finish shortly after lunch. Okay, well, let's see how it goes. Okay, good. Okay.
Thank you. Thank you, Malan. I won't count the 5 minutes that we've used here for the arithmetic lessons from Mr. Tengo.
That was your fault, Mr. Mpofu.
Thank you. My lords and my lady, on the merits of this matter, I propose to do to approach it in an unconventional manner that will hopefully assist to focus the issues but also to assist the court in really focusing on the real issues. You know, lawyers, we all have all these thousands and thousands of pages, and we quote hundreds of cases and so on. But usually a case really can be reduced into 2 or 3 broad propositions at the end after all is said and done. So what I'm going to do, firstly, let me start by saying this. The reason that I was speculating that we might run a bit over is because on the merits, we're going to break the argument into 2 parts. I will deal with the suspension of the SG, and my learned friend, Ms. Cellular SC, will deal with the suspension of Mr. Ramaphosa. So if I eat into her time, then well, that's the price to pay. So I'll obviously the main chunk of the time will be spent on my section. Also because of the dynamics of the case and the fact that the other suspension in our respectful submission is a much easier one to deal with. Now, that being said, the approach is still going to be the same as what I have structured. And my approach, the hopefully helpful approach, is going to be this. I'm going to address the court very briefly on what I call the regulatory environment and framework. Then I'm going to talk quite a lot on the Ramakata decision of the Constitutional Court in Ramakata. Because in my respectful submission, as I say, this is probably one of those cases, quite frankly, where counsel could have just come to the court armed with one authority. I don't think there's ever a counsel who's ever dared to do that in a matter of this size. But you know what I mean. All the real serious principles that we're going to be dealing with today are contained in Ramakata and various other judgments, obviously, that came after it. In particular, there's a case of Dube, which was before the full bench in KZN. There's a case of Delil, which was before the full bench in the Western Cape. And there's a case, I don't think we included it, but I might also rely in a case of Motswana, M-O-T-S-W-A-N-A. I apologize if you didn't include it. That was decided in this division by her ladyship, Katrisi Tilwane. That was a case of the Northwest. So so if the court will forgive me for spending so much time on Ramakata, on the basis that I will compensate for that by not spending a lot of time on other cases. So that's the broad framework. The case of Ramakata happened in 2012. Incidentally, apart from the fact that I was involved in that case in the Constitutional Court, but it was, and I was acting for Mr. Ramakata, but it is Ramakata versus Magashule. So the opposite number was my client for today, and we were successful against him. And I was saying to him, or rather he was saying to me, that, well, if the principles on which I won against him are to be upheld, it can be that now when the shoe is on the other foot, those principles will not apply. You were saying that on a lighter note. So that's the second bit of what I'm going to do. Then I'm going to use this kind of shorthand. The meat of this case is contained in 22 pages. You know, we all have 900 pages. I think that's what Ms. Kofa said. But as I say, sometimes most of it is not completely necessary. I'll take the court very in more detailed fashion into the following in the pages at these are annexures to the annexure, or rather the affidavit of Mr. Ramaphosa, which is CR 6 to CR 11. Case lines, it's 003 -643 to 003 -663. And in my respectful submission, if we have time to go through those annexures, it will literally be able to cover the whole case. So regulatory framework, Ramakatsa, and a few other cases, and then those 22 pages. That's my signposting. Now, starting with if you go to our heads and just look at the 8 questions that we say this court has to answer, that you'll find at 008-123. So the first question, should condonation be granted? We have dealt with that. Second question, should the application to strike out be upheld? We've dealt with that. That's 12.2. So the remaining 6 questions are the following. Is Rule 25.70 of the ANC Constitution constitutionally and legally valid? So all of them are yes or no questions. So it's yes or no. If it's yes, and I'll come back to this. If it's yes, if it's or rather, if it's no, if it's constitutionally invalid, then I will address the court to say that's what we've suggested in the papers is a shortcut. Should it be found that that rule is not constitutionally sound or constitutionally defensible, that will be a major shortcut, because all the other questions in a way are linked to the question of 2570. For example, you'll know that the letter of suspension refers to 2570. So clearly, if 2570 is bad, then the half of that letter is almost gone, or an indispensable portion of that letter is gone. And then we then say, yeah, if so, but let's assume we're wrong. Let's assume 2570 is valid. If it's valid, then is the step-aside rule or regime in any event constitutionally and legally valid? And I want to pause here again to emphasize that our approach is not the same as that one of Mr. Sikakane, who was attacking the entire regime. As the court might have noticed, ours is maybe a less radical approach, which says that the NASREC resolution, we accept it as having been an effort to fight against corruption and so on, and to bring in morality and what have you. But our main attack is on what we call the NEC resolution. And we use that terminology advisedly. So we will be distinguishing between the NASREC resolution, which is the National Conference resolution, and the NEC resolution, which we say is completely unlawful. That is the reconfigured, repurposed version of the step-aside regime, which we say has been unlawfully doctored to suit certain purposes. That is invalid. But again, as lawyers do, we say, let's assume we're wrong again on that. Then the next question will be at 12.5, which is, if so, in other words, if the NEC resolution survives, is the Magashule suspension letter dated 3 May 2021 valid? Because it may well be that 2570 is valid. It may well be that the step-aside regime is valid. Obviously, if those are not valid, then we go home. That's the end of the case. But if we're wrong, the letter of suspension itself may be invalid, in which case we still get the relief. Then we say at 12.6, irrespective of the answers to some of the questions raised above, is the Ramaphosa suspension letter dated 3 May 2021 enforceable until lawfully set aside? Which is that's the question about on 2.2, I think it's prayer 2.3. That answers that question. That's the part that my learned friend will deal with. And then we say, finally, is the decision of the NEC to demand a withdrawal of the Ramaphosa suspension letter and an apology for its issuance valid and or enforceable? That's obviously linked to the previous question. Not inextricably, it could be seen as a standalone issue, but it's somewhat linked. And then the last point is costs, which we've already started to talk about costs in respect of the condonation and the strikeout application. So there are really 5 broad issues that we raise if you put aside the question of costs. Now, let me start by saying this. Fortunately, the facts in this matter are largely common cause. And that is a function of 2 things. It is because most of the facts are just irrefutable, but also because even where there's been a half-hearted attempt to make denials, those have been largely bare denials. For example, you'll see in the affidavit of Ms. Duarte, I think there's a place where she just deals with like 20 or 30 amendments by one line to say these are denied. Yeah. So as we know, bare denials don't really cut it. So either because of that kind of analysis, the Plascon-Evans or Whitman, the well-known tests about the bare denials not being effective, or simply because the facts are just common cause anyway, in the sense that they are admitted. Of course, there are quibbles here and there, but the point I'm making is that largely the facts are common cause. Which then takes us to my first issue about the regulatory regime. That you'll find at 008, it's summarized at 008-129 of our heads. That's our heads. But also maybe more fully dealt with in the founding affidavit at 001-43. In fact, yeah, if we can use that one, because that one has quotations.
Sorry, Mr. Mpofu, is that the one that starts on paragraph 130?
133, my lord. Yeah, the section starts at 132, where we say the applicable legal framework.
Okay.
133 of the founding affidavit, Justice Mulahledi. Are we on the same page?
And that starts with the applicable legal framework. Yes, I found it.
Correct. Yes. Thank you. Thank you, my lord. Yes, that section, yes. Yes, so let's go to paragraph 133 very quickly, because this is really the base of the constitutional attack. The Constitution makes it clear, some of these statements are made glibly without examining their implications. The Constitution says at Section 2 thereof, this Constitution is the supreme law of the Republic of South Africa. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. Now, the accent is on conduct, because here we're dealing with the conduct of the ANC, so to speak. In other words, if we can show that the law, that the conduct of the ANC limits any rights that are enshrined in in the Bill of Rights. So I'm using the word limit advisedly. I'll explain later why that is important. Then the court has no option in the matter, by the way, in terms of Section 172(1)(a). Once it is found that a right in the Bill of Rights has been limited, then the court must declare that conduct to be so and render it invalid for that reason alone. Right? And then 172(1)(b), as we know, says then the court may give this and that relief and so on. So the difference between the word must. I'm sorry. Sorry,
Mr. Mpofu. You said if the court should find the right is limited, then they must make a declaration. But 172 speaks of conduct that it's inconsistent with the Constitution. So a right may be limited, but it may still be consistent with the Constitution, not so. The Constitution contemplates that there could be a limitation of a right, but that nevertheless it would be consistent with the Constitution. So the test is inconsistency.
Yes. No. I'll show you. Yes. In fact, that's why I was saying I use that word advisedly. There is that mistake of assuming that a limitation, Section 36, for example. That's why in Ramaphosa, which we will go to, it is said that once the infringement is shown, then the only way out really for any respondent is Section 36, as your Lordship knows that. But the reason Section 36 is called limitation clause is because it is deliberately made to give you the minimum wrong you can do, if you like. And that is why if you go to the Bill of Rights Handbook by Curry and Duval, which is the 6th edition, a very good handbook on these issues. If you go to page 151 of that book, the following is said. And that is, the chapter is on limitation of rights. That's why I was saying I'm using that word advisedly. It says, in the constitutional setting, limitation is a synonym for, quote, infringement, or perhaps justifiable infringement. A law that limits a right infringes the right. And then, however, an infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing the rights and so on, which is the point that I think Justice Collerpen is making. But the most important issue is that the mere limitation, quote unquote, on the word mere. I don't know why we have Mr. Nglasan. Oh, the mere limitation of a right, Justice Collerpen, is sufficient to kick-start the obligations that arise from Section 36. So it is in that sense that I'm using the word. But I accept without any quibble that if you are able to mount a Section 36 defense, the point that was made very eloquently by Justice Museneke and Justice Jafta in Ramaphosa, then of course, but I make 2 points about that so that we don't even have to waste time on it. Firstly, it is that there is no Section 36 defense in this case of today. So whether we're dealing with a limitation or whatever, it's for that purpose, it's irrelevant. Even if we didn't know that limitation is a synonym for infringement. That defense, because we would have to engage with that if there was a Section 36 defense, but there is none. So all we really need in this case is very, very, very simple. We simply have to show this court that the rights, Mr. Magashule's right, as enshrined in Section 19 of the Constitution, which is the primary right we are asserting, have been infringed or limited. Full stop. Once we do that, this court has no option. It must grant the declarator. Must. That is what the Constitution says. It's not some optional extra or whatever. Then so that's what we mean by the standard that is set at 123 number. I'm sorry. Yes, number 4. Let's say number 4 and 5. That deals with the issue of the step-aside regime. I'll deal with it in the context of Section 19, and if so, is the Magashule suspension valid? So that's Section 2 is a very important springboard for what we are busy with today. Then Section 9 of the Constitution, we all know, is the Equality Clause. There we emphasize the right to equal protection of the law. Now, by that, we take liberties with particularly with the words "the law." The law. Sorry, Mr. I'm sorry. Yes, Justice Wynne.
Sorry, I just want to. We were dealing with Section 19 of the Constitution, and you said once that is infringed, it must be declared invalid.
Yes. No. I'm sorry. I'm saying the conduct must be declared invalid.
But there is the rider to that, as was held in Ramaphosa, that Section 19 does not spell out how members of a political party should exercise the right to participate. That's up to the political parties to regulate themselves. Exactly.
That is why, you see, this is the point about being able to differentiate between Section 172(1)A of the Constitution and Section 172(1)B. Which is the common mistake that is made. What that case said is exactly that. In terms of Section 172(1)B, which is what you might call the consequential relief that emanates from invalidity. Yeah. Then the court, that's why the court, I argued that case, and I was saying to the court, not only must you declare the conduct of the Provincial Executive Committee invalid, but you must also say that this conference, I can't even remember now, this conference must be held next week. Let's say, I'm just making up that part here. And then the court says, well, Mr. Mpofu, you can only get the declarator because we have no choice in the matter. Once we find that Section 19 has been infringed, we have to give you your declarator of invalidity. But when it comes to the discretionary part, may, Section 17, that's why the first word in Section 172(1)B is may. When it comes to that, then as the court, we are now in the usual way, we can say, oh, well, and it was in that context that those words were made. In the heads of argument of the other side, those words are being quoted out of context. It was in the context of 172(1)B, but those words can never have anything to do with Section 172(1)A, because it's the obligation of the court. Actually, there's no other institution in this country that can declare conduct to be invalid except the court. So it's a fallacy which is often bandied about. People will even say it's like in this thing of separation of powers. People say, no, but the court can't dictate to Parliament, or can't dictate to the President, or can't dictate to the executive. No, that issue comes into play only in terms of 172(1)(b). But it doesn't matter whether you are the President or Parliament or whoever. If you have infringed a constitutional right, the court must declare that conduct to be invalid and inconsistent with the Constitution. What it then does with it, then you can talk about separation of powers. The same thing, remember this defense about so-called political party can do what it likes and so on, is a miniature version of separation of powers. In other words, what it's saying is that the court must not encroach into the terrain of the political party. But as I say, all those nice debates only belong to the second leg of the 172 test. They have no place whatsoever in the first one.
So are you saying that by Mr. Magashule being suspended and excluded from certain activities, that is automatically unconstitutional in terms of Section 19?
Well, it's up to the court. If the court accepts that whatever has been done to Mr. Magashule amounts to this, a limitation, as we have said before, or a violation or an infringement of his right to participate in a political party of his choice, then the answer is a big yes.
So in other words, a political party cannot suspend anyone.
No.
Because then they're infringing on their right to participate in that party's activities. No. That's another mistake that the heads of argument of the respondents make. Surely it can't mean that. It's like saying. What does it mean? Okay, it means this simply. It's they call it a two-stage inquiry. Constitutional analysis is a two-stage inquiry. The first one is infringement. The infringement part simply says, I have, let's take the most blatant example. I have a right to freedom, to movement. Sorry, Mr. Mpofu, won't you use the facts of this case to demonstrate your point? Because I think it's quite relevant in that sense.
Okay, well, then I've answered the question. The answer, yeah, on the facts of this case, all you have to do is to go to, in fact, the words come directly. Let's go to the letter of suspension, my lady, which is SG7. You'll find it 00180.
Sorry, there's somebody who's got the microphone that we can hear you talking in the background. Oh, maybe it's your junior. Sorry.
It is, my lady.
Okay, sorry, I just was having this interference.
No, you're saying, I'll tell them to rather whisper or write a note.
We'll pass you a note.
Yes, you are frozen. Oh, I can see you now, my lady. Yes.
So the letter of suspension is which one? Where are you referring to?
Yes, my lady. It's on 001-80.
Yes.
And I will take your ladyship specifically to paragraph to 001-81, which is the next page.
Yeah.
Now, let's go to section 19 first. Section 19 says, every citizen is free to make political choices, which includes the right to participate, underline the word participate, to participate in the activities or recruit members, forget that, of a political party. And that in Ramakatsa was correctly interpreted to mean there is a right to participate in the political party of your choice, which we all, I'm sure we all accept. Now, then go to 001-181. And what is the conduct? It's uncanny they actually use the word of the Constitution. It says, in terms of Rule 25.70, the following terms and conditions are imposed to regulate your participation, right, and conduct during your temporary suspension. And it says, during the period you are temporarily suspended, you may not carry out the duties, may not represent the organization, may not make public pronouncement, may not engage the mobilization of the ANC. So what I'm saying to answer, if we all agree, which we must, that all those four things amount to the limitation or infringement of his right to participate in a political party of his choice, then the infringement part is done and dusted, right? Then we go to the issue that Justice Colapen was alluding to. We then obviously, as everybody knows, there's no right that is absolute. That is why we have something called Section 36. Section 36 is the limitations clause, which definitely makes sure that you can't just say, look, I have a right to do whatever I want, otherwise there'll be chaos in the world. It says, I'm sorry, I'm just going back to Curie and Duval. They say, in other words, not all infringements of fundamental rights are unconstitutional. That's an answer really to your question, Justice. Where an infringement can be justified in accordance with the criteria in Section 36, it will be constitutionally valid. So that's the standard. So there's no such thing. You can't just say, well, it means nobody can ever be suspended, because the Constitution gives you that answer. It says it puts its own standard. In other words, and it says it must be emphasized that the existence of a general limitation section does not mean that the rights in the Bill of Rights can be limited for any reason. It is not simply a question of determining whether the benefits of a limitation to others or to the public interest will outweigh the cost to the right order. If the rights can be overridden simply on the basis that the general welfare will be served by the restriction, then there is a little purpose in the constitutional entrenchment of rights. What does that mean? It means we might as well take the Constitution and throw it in the dustbin if we are going to take the approach that says, yes, we may infringe rights because, you know, we want to stop corruption or whatever. The only way in which you limit rights, constitutional rights at least, is by Section 36 justification. And that was done for a reason. It comes from the German and the Canadian constitutional history, particularly the Canadian one, which is the one that we follow. That a limitations clause must be the only, that's why it's called it's not just a statute or some section or in a regulation. It's a constitutional, not just even a constitutional provision, it's in the Bill of Rights, nohal, which means it is very protected. And that's why the Bill of Rights itself provides the mechanism by which you can limit it.
Okay, sorry, can we go? Sorry,
yeah. Thank you, Mr. Mpofu. I just want to clear up a conceptual difficulty that I need to bounce off you.
Yeah.
It's common cause that the agreement between the ANC and its members is described as contractual in nature and uniquely so.
Yeah.
I also take the view that space within which the parties contract is not insulated from the Constitution, and you can't build a wall between that.
Yes.
But out of that arises then, what is the scope and the applicability of the Bill of Rights with regard to these relations?
Yes.
And I ask this in this question, that rights by necessity are defined. Some of them are universal in their application, but not all of them are. So there's some rights that accrue to citizens only. There's some rights that accrue to accused persons. There's some rights that are triggered by the exercise of power. in the context of the scope of the application of the rights regime, Ramaphosa also tells us that there's a carve-out, that in Ramaphosa, the court affirmed the right to political participation, but carved out a space that the court would not interfere, where it says how they will participate. So my conceptual question to you, and the Constitutional Court has dealt with this in Barkhuizen and in the Bidika case, that you can't take contractual provisions and simply test them against the Constitution as a freestanding set of values. That the process must be, well, to enforce such a provision, would that be contrary to the legal convictions of the community? And if the answer is yes, then you wouldn't enforce it. So the test is somewhat different from simply saying there's an infringement. And my question to you is, conceptually and jurisprudentially, what is that terrain between the freedom of the parties to contract, and Ramaphosa has recognized some spaces that the parties must be allowed some deference, and the applicability of rights? Because before one can speak of infringement, one must first establish applicability, because yes, you can only infringe if it's applicable. If it's not applicable, you can't infringe. Yeah.
Yes. No,
so that's just my conceptual question.
Yes, yes, no. And it's a very valid one. I understand the question perfectly, Justice Colapan. The first answer is the one that I made, which is the distinction between 172.1a and 172.1b. I won't repeat that. I've made that submission. That's where the conceptual difficulty arises, is because of the conflation of those two. I've made that point, as I say, I won't develop it. If you understand, the Ramaphosa decision says exactly, if you remember, Justice Colapan, the order in Ramaphosa, I think you'll find it at paragraph 133 of that case. Order number 3. That was the declarator. That's the 172.1a relief, which we sought there. And the court had no difficulty whatsoever in granting that order, because it says the Provincial Elective Conference of the Free State Province of the ANC held at Paris on the 21st, 23rd June 2012, and its decisions and resolutions are declared unlawful and invalid. That's 172.1a. The court had no quibble or hesitancy whatsoever to grant that order. What the court then did not do is to grant, assume, for the purposes of this, when I was answering Justice Wiener, assume that I had also asked for another order there that says it must not be held in Paris, it must be held in whatever, in Kronstadt. Then the court said, well, okay, that much. When we're now coming to the other relief in 172.1b, we have to give this quote-unquote deference to the fact that this is a voluntary association and so on and so on. But the mistake of conflating those two things leads to very serious consequences. That's number one. Number two, at paragraph 72 of Ramaphosa, you'll find the following, which is really captures what I'm saying.
What paragraph, Mr. Mpofu?
So I was saying 72, my lady, but let's start at 71. Okay. Because 71 and 72 read together make the point, put it in perspective. This is what Justice Musaneke and Chafta said, and that really should put this issue to bed of where does the limitation come in. Okay. At 71, it says, my Lord, in the relevant part of section 19.1. Oh, come on. So,
well, can we make this suggestion? Can everybody, Secretary, of the court, could you please mute everybody that's on the platform except for Mr. Mpofu and ourselves? I think let's control it centrally, because otherwise we're going to get all this disruption throughout.
Oh yes, the host can mute everyone.
Yeah, the host should mute everyone.
Yes, thank you.
Sorry,
Thank you.
Judge.
Thank you.
If I mute all, then everyone is muted.
Or
Can they unmute themselves? If Mr. Trengov maybe wants to come in, will he be able to unmute himself?
Yes, yes.
Okay.
Okay.
So if I'm going to mute everyone now, then the judges will have to unmute themselves.
Okay.
Okay.
Thank you very much.
Thank you.
Thank you. Can the court still hear me?
Yes, yes, we can.
Yes.
Okay.
So
Got to unmute yourself.
okay, that was okay. I think she muted everyone literally, including me.
Yes. No, that's what you were saying. Everyone is muted, and then only us can unmute.
Yes, the onus
And-
is on us.
Sorry, Mr. Mpofu, can I just suggest no one unmutes yourself, because it's very disruptive.
Yes, thank you. Thank you, my lord. All right, so it says 19.1 proclaims that every citizen in our country, that includes Mr. Magashule, is free to make political choices, which include the right, there's that magic word again, to participate in the activities of a political party. This right is conferred in unqualified terms. Let me pause there. As Justice Kolopen was saying, there are rights which says, this right maybe applies to people who are under 20 or whatever. The right to vote, for example, is if you are under 18, you don't have that right. Yeah. But this right to participate in the political activities of a political party is expressed in unqualified terms. Consistent with the generous reading of provisions of this kind, the section means what it says, and it says what it means. It guarantees freedom to make political choices, and once a choice is made on a political party, or rather once a choice on a political party is made, this section safeguards a member's participation in the activities of the party concerned. In this case, the appellants and other members of the NC enjoy constitutional guarantee that entitles them to participate in its activities. It protects the exercise of the right not only against external interference, but also against interference arising from within the party. Can't be clearer than that. In other words, it protects you against intra-party interference. It's not just a right that may be abrogated by others or members of another party or whatever, but by your own, right? And then it says this right may be limited only, unless if the word only means something else. This right may be limited only on authority of a law of general application, but even then, only to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. And here comes the point I've just made, which applies to this case. As no law of general application has been invoked to justify the limitation here, in this case that we are doing today, it follows that if any limitation is established, right? If any limitation is established by the appellants, Mr. Magashule in this case, it will be unjustifiable. It can never be clearer than that. What this means, I'm sorry, can I just finish that last sentence, please? Please, yes. What this means is that constitutions and rules of political parties, like the ANC, must be consistent with the Constitution, which is our supreme law. And then they say elsewhere that Section 36 was not invoked and so on. In fact, the footnote to footnote number 52 then quotes section 36 in full. So that's the second answer. Oh, I'm sorry, Justice Wena.
Yes, I just want to go on because it goes on in paragraph 73, which you said was taken out of context. But isn't that a continuation of what's said in 71 and 72?
No, it is. Okay, now we're going back to the 172.1a and b problem. That issue, Justice Wena, at paragraph 73, which I was going to move into now, addresses one issue and one issue only, the issue of remedy in respect of 172.1b. And again, as I say, I don't want to revisit the point I made. It does not have anything to do with 172.1a, which is the declaratory relief. That is why in this case, because as they say, madness is the definition of madness is doing the same thing and expecting a different result. So in this case, that is why we confined our relief under 172.1a to the declarator, because it has to conform with the Ramakatsa standard. If there was no Ramakatsa and there was no paragraph 73, which is the one that's quoted out of context, because its context is 172.1b, then we would have gone on to say what else must happen, that this one must do this one must never be able to go to Lutuli House and what have you. But we can't do that because of that paragraph 73. But anyway, the question raised by Justice Wiener takes me to the third answer to Justice Kolapel, which is really the nub of the issue. Look at the heading before 73. Once they've made this point that you can only justify a limitation to participation by section 36, then they deal frontally, Justice Kolapel, with your question, which is really this, and that's the philosophical jurisprudential question. What is then the interplay between the constitutional right and the contractual right? And that's the point that must never be missed. That's why the heading there says interplay between ANC Constitution and Section 19. Paragraph 73, Justice Wiener has already referred to it. That's the one that deals with your point you are making. We have to give recognition. It could be a company, it could be whatever, that it has its own contractual space, which Pacta Sunt Servanda protects. So the Bakhazen cases, Justice Kolapel, have no application here because, well, not in this context. I'll deal with Bakhazen in a different context when I answer the defense, quote unquote, that this is a private thing and what have you. But in this context, the Bakhazen cases have no application. The Bakhazen cases have to do with a contractual relationship. I think in that case, you might remind me, Justice Kolapel, it was a surety ship or whatever, something like that. Yeah, that's what the Bakhazen cases deal with. They deal with a pure contract, if you like, and the extent to which the constitution of the country, which we know because of Section 8 of the Constitution applies to all of us. Doesn't matter if you are a private, whatever. But and that's what the Bakhazen cases deal with. But this contract has been described as a sui generis contract, and the reason it is described as a sui generis contract is because of what is said in paragraph 74. It bears repeating that political parties may not adopt constitutions which are inconsistent with Section 19, full stop. What does that mean? That means that in the non-Bakhazen cases, cases like the one we have here, in Bakhazen, nobody can stop you. In the Bakhazen type of cases, nobody can stop me from buying a car at an exorbitant price because it's private relations. But once you are dealing with a contractual right which is clothed in the constitutional right of Section 19, such as this one here, then you are in another terrain altogether, because the freedom that you might have had under the Bakaysan cases is no longer there, because now you are restricted by the by Section 19. That's why a political party cannot say, we are going to have a political party that's going to only admit men. A social club downtown in Johannesburg might do that, and it might have its reasons to do that. But a political party cannot do it. Why? Because that would be an infringement of Section 19, which says every citizen, whether it's a man or a woman, has a right to participate in the political party of their choice. So if a woman wanted to say, I want that party, that men's party, I want to be a member of it, you can't say, no, but clause 20, look at clause 20 of our constitution. It says it's men only. You'll be laughed out of court, because that woman will say, but Section 19 guarantees me the right to participate in your party. So your clause 20 can jump in the lake. I'm going to be a member here, which she wouldn't be able to do if it was the country club or whatever.
But Mr. Mpofu, sorry to interrupt you.
Right.
Moving into this argument, you started off by referring us to the letter of suspension.
Yes.
And it sounds to me, from what you've even quoted in the letter of suspension, your argument is based on a total exclusion from exercising political right by a member. But in this particular case, and I think Judge Waina alluded to that earlier on, in this particular case, if you look at the paragraph that follows after the 4 points listed in the letter of suspension, it actually provides a suspensive condition on those rights. It doesn't take them totally away. But listening to you, your argument seems to be focusing mainly on total exclusion or breach of the rights. Here, as I see, those rights are suspended pending some outcome later on.
Yes, I've already answered that question, Justice Bulatley, when I was answering Justice Kolapen. If I gave you any impression that I'm saying that the rights were totally taken away, then I apologize. That is not what I'm saying. I am saying the limit, that's exactly why we had the debate about limitation. The mere limitation, whether it's 10%, 20%, 30%, 40%, 50%, 60%, the limitation of a right in the Bill of Rights is an infringement. That's the part I read out in Curry and Duval, right? That's the law, it's not me. If you limit, that's why the word limitation in constitutional speak means the same thing as what you are saying, violation, infringement. The fact that it's a partial limitation is neither here nor there.
And
I hope that's the,
the concept of, sorry, Judge Wina, go ahead.
No, I was just saying, but aren't we back to the question of then nobody would, the party would not be able to suspend anyone?
So before you answer that, in fact, just to add to that, Judge Wina, what it then means in our law, we would not know the concept suspension. No. And we know that there's a whole jurisprudence in various fields of our law where suspension is recognized as one of the tools that can be used, particularly in the employment arena.
Forget suspension. There's another thing called expulsion. Even that is allowed, all right? The point is not that you may not suspend. You can even expel or kill or do whatever you want. The point is this: if to do that, you must do it lawfully. That's where the buck stops. You must do it constitutionally. Nobody says you must never suspend anyone. I mean, that's...
So Mr. Mpofu, I think just to ask you that, You're saying you can suspend, but you must do it lawfully.
Yes,
So,
in other words, constitutionally in this context.
So coming back to your question that you posed, 12.3, is 25.70 constitutionally and legally valid? Can it be contended that to the extent that all that 25.70 does is to create a mechanism for someone's suspension? And even if that question is answered in the affirmative, it doesn't necessarily answer the other question, is the suspension letter valid?
Yes, no, of course.
So,
thank you.
So
thank you.
On the face of it, it provides for criteria that you say were not met, but in any case, it provides for some jurisdictional requirements to be met before a suspension can be effected. So yes. On the basis of what you said, what is the complaint with regard to 25.70 from the perspective of it being constitutionally invalid?
Great. Thank you, Justice Kolopen. With respect, that's a great question because it goes to the nub of what I call the shortcut. If, and I will then go and address the issue of the constitutional invalidity of 2570, because as I said earlier, if we are good on that, then basically the rest of the case just falls away. Let's start like this. Let me, because of the questions that I've received, let me start by making the following disclaimer. If I say anything in this court that suggests that 2570 is unconstitutional merely because it provides for a suspension, then you must kick me out or mute me or do whatever. That is not our submission. Okay? Obviously, very obviously, an employer, a soccer club or whatever can suspend and do this. The only caveat is that it must do so lawfully. And if it's a constitutional setting, it must do so constitutionally. How do you do so constitutionally? By justifying that prima facie infringement by Section 36. So in other words, that's what I was saying. Unfortunately, Justice Wena stopped me. I was saying somebody can say, if you imprison someone, you are stopping their right to movement. There's no doubt about it. You are limiting their right to movement. But why is it allowed? Because there is a constitutional justification for doing it. You've infringed section so-and-so, you've been to court, you've had your Audi, you were sentenced by a magistrate, therefore, I'm sorry, I'm going to now lock you up. It does not mean you are not infringing that person's right of movement. You are, but you have a justification. That's what the relationship between Section 36 and the rest of the Bill of Rights is exactly that. So similarly here, by the mere suspension, you obviously are limiting the rights of participation. But the question is, do you then have a countermanding justification? Yes or no?
I follow that, Mr. Mpofu.
That is, okay.
But just on that score,
yes.
Then in response to my question, textually, is 25.70 offensive? And if it is, on what basis is it offensive textually?
Yes, I was coming there. Textually, and I'm sorry to take you back, assume for the sake of what you call it, exaggerating for effect. You remember the example I made, there's a clause in the Constitution that says only men, no women. Let me show you why 2570 belongs to that school of clauses. We say that 2570 on its own four corners, in other words, textually, as you put it correctly, Justice Kolopen, provides for a suspension without a hearing, right? Unlike all the other suspensions in the ANC Constitution, this one provides for a suspension without a hearing. And that I don't think I need to develop that. If I'm right on that, then it would be unconstitutional from that point of view. We say, secondly, that that provision insofar as it says, if you are charged for any offense whatsoever, we say it violates the presumption of innocence. Now we can interrogate whether that is. I'm just giving you the headlines of why of the criticisms against 2570. And if we're right in that proposition as well, forget the Audi one, then that clause must be kicked out of existence. We say, thirdly, that that clause does not provide a member the right of appeal, which is an inherent right, which is part of Section 34 of our Constitution. But listen to this, Justice Colopin. And this is why our learned friends are constrained to say something which is outlandish, like the clause 25.70 is not a disciplinary clause, or it's not punitive. I mean, really. But they have no other choice, because they have to say that. Why? Because if they, once they concede, as they should, that clause is disciplinary and it's punitive, then it obviously attracts Audi. Then it obviously attracts the right of appeal. And it might be debatable, the issue about the presumption of innocence. There's a lot of debate, and that was raised in the recent case of Zuma versus the public protector, or the other way, not public protector, the Commission on State Capture versus Zuma. So there might be a debate on that third ground. We assert it as we see, but for the purposes of this discussion, assume that we're right on those three scores, Justice Colopin. Then there is no way that that clause can survive constitutional scrutiny.
Would you agree that you would be right on those clauses if one answered the anterior question as to what is the nature of the action taken? And you've touched on that. You say it's disciplinary, and because it's disciplinary, it triggers those guarantees. If it was not characterized as disciplinary, and our jurisprudence does to some extent deal with suspensions that could be disciplinary, that could be punitive, or that could be preventative.
Yes.
And so not all suspensions would trigger those Audi rights, correct?
No, that's not correct. The distinction between suspensions is as follows, Justice Colopin. And again, this Justice Molahlehi will be more at home here as a labor specialist. There are two types of suspensions. And even in the ANC Constitution, by the way, you'll find that both of them are foreshadowed. There's a suspension which is a punishment, in other words, which is a sentence. So let's say you go through your DC, you're found guilty, and then they say, okay, your sanction, Mr. Magashule, is a suspension. You will be suspended for 3 months. That is one type of suspension. There is the other suspension, which is the more usual one, of suspending you pending that disciplinary hearing. In other words, not after it. Now, that is the suspension that we're dealing with here. It's that type of suspension. The suspension which comes, which is not punitive per se, in the sense that it is a sanction, because nobody can argue about that, is in itself punitive, in the sense that it takes away your right to work. Let's take the workplace example. So I say to Ms. Kofa, Ms. Kofa, you are my junior, but now I'm suspending you for the next 2 weeks because you did this and the other. So there cannot never be any debate that is punitive, in the sense that it takes away her rights. But except that I'm saying, but in 2 weeks' time, I will give you a proper DC, and you might well find yourself to be innocent. So that is why those suspensions in their own right, that's why in the normal workplace situation, they say you must show cause. They write you a letter. Dear Mr. Mpofu, please show us cause why you should not be suspended. There's been an accusation that you stole this and the other. Your DC will be next month in July. Please show us cause why we should not suspend you between now and then. That's the Audi that I'm given. Then I say, no, this and that and the other. They look at it and they say, well, we're still going to suspend you. I can't then run to court and say, I was not given a hearing. I can run and complain about other things, but not Audi. So that is the Audi we're talking about. It's not the one of the sentencing, so to speak. It's the one of it's called the pre-suspension hearing. So, sorry, Justice Malthe, yes.
Yes, no, I just wanted to say, it seemed to me, well, let's come back to 2570.
Right.
You could have a clause like that. It does not necessarily make it unconstitutional. However, what you seem to be saying is, if you have a clause like that, your audit principle and your fairness principle would inquire when you implement that particular clause, you ensure that the other party is given a hearing, because you're going to be taking away certain of their entitlement. Let's not even go rights. Some of their entitlement is to be in the office. It carries with it some dignity because it's got status and all those things. And therefore, if you have a clause like then, the consequence of your conduct of suspension has to be tested on the basis of whether that person was notified as to say you called upon to come and show cause why you should not be suspended.
Thank you, Justice Mulahleli. That assists me a lot, that question, because it distinguishes between two things that I'm saying. The first thing I'm saying is that a clause, again, if the court can indulge me, just assume for a minute that I'm correct that the clause not only offends against Audi, but offends against the presumption of innocence, let's say. If that is so, then per se, right, forget the implementation and all that, per se, that clause is unconstitutional, okay? Because it's the same as the one that says men only, because it offends against the principle, the right in section 35. Similarly, coming back to your question, similarly, when we talk about the first leg of our attack, which is the Audi leg, not the presumption of innocence leg, the same thing applies. I don't think I have to convince this court, at least, that if a clause, let's assume, and again, I'm taking liberties here, Justice Mulahleli. Let's assume there was clause 25.70b that says, 27b, you will not have a hearing in this for this suspension. There's nobody in this world who can argue that that would be unconstitutional. So it comes to then to your question. There are two ways of answering your question. It is this: the principles in constitutional interpretation may be used twofold. The first way in which we want to invoke it is to say the clause textually, as Justice Colapen put it, offends the Constitution because of the deficiencies that I have outlined. The other way is the one that you are alluding to, Justice Mulahleli, where you could say, okay, I hear you, but isn't it also true that in terms of the rules, forget even the Constitution, the rules that come from the Jockey Club cases and other rules of interpretation, that the court, before it can strike out a clause, it must try to interpret it to be consistent with the Constitution, which point I will concede. if you take that second leg, then the problem for the respondent is then going to be the following. I'll say, okay, Justice Malahlei, I give up. Here's the white flag. I say then let's interpret the clause as requiring Audi. Then we say, was Audi given? And that's the implementation point that you are referring to, Justice Malahlei. In this case, it was not. So they will still fail at the implementation stage, but we're not there yet. I'm coming there, where I'm going to show that even if it could be interpreted generously to include impliedly the right to Audi, that was breached anyway at the contractual level. So either way, it doesn't really matter for my purposes, whether you find that 2570 is per se unconstitutional because of the reasons I've given. In other words, forget the Audi now. Let's say you say it's unconstitutional because of the presumption of innocence or the right of appeal. But you say on the question of Audi, we are choosing to interpret it as requiring Audi. Then I will say, okay, let's then move to the next leg. Was Audi given in this instance, yes or no? If the answer is no, the suspension is still unlawful. So there's no answer. But I accept without reservation the principle that you assert, Justice Malahlei, that it might well be that the court takes a more benevolent approach on the Audi point and say, we'll interpret this as the Jockey Club cases say. Even if a constitution of a voluntary association doesn't say you will have a hearing, once they have to suspend you or expel you or whatever, it must be read impliedly as asking that, because the rules of national justice are implied in every contract.
If you accept that argument, the validity of the clause,
Right.
and if we are to fall back onto the labor jurisprudence, isn't it that there is also recognition that in the application of the principles of fair hearing, firstly, principles of a fair hearing entails a more flexible and a balance between the interest of both parties, and that in balancing the interest of an employer, for instance, you would take into account that the seriousness of the offense that an employee is being accused of. If, for example, I'll use an analogy again here, an example, an employee has embezzled money and has ciphered huge amounts using very technical electronic systems. For you to go through the hearing process, you are actually running a further risk of losing the money. And as I understand the jurisprudence there, is that the employer may, in those circumstances, be justified not to fully implement the fair hearing and the OD principles.
Absolutely. Absolutely, Justice Malahlei, you are on point. Except that in this case, none of those things have been invoked. That's the point I was making, that if let's say we forget about the unconstitutionality point now. I'm talking now at the level that you're asking me. Let's say we've moved from there, we're now talking about implementation. If the respondent had said, look, court, we know that we have a duty to give a hearing. In fact, we give it all the time. But as you say, this person was busy running amok in the office and stabbing everybody. And you can't expect us to say, oh, well, you can stab everyone, but we must give you your Audi. But none of that is invoked here. Nobody here has said there was any sudden emergency, which is what that defense is called. None. On the contrary, on these facts, when the so-called 30-day had expired, the employee was invited to several meetings. He came to this meeting of the Women's League. He was called to this and that other meeting. It's the exact opposite of that sudden emergency situation where you would have said, obviously, we concede that there's a duty, a general duty of Audi, but the circumstances, as you call it, Justice Malahlei, of the particular case required a no court will come and say no, you should have given Audi even when the person was busy breaking every window in the office. But it doesn't apply here.
Just the last point from my side, and the point you're making now. As I understand, the SG is both an official and an employee.
Right.
But the case you have made on your papers is not related to the status as an employee. You've only made a case in as far as the status of SG, or am I getting it wrong there?
No, well, you're getting it right and wrong.
Can you hear me, Mr. Mpofu?
Yes, I can hear you, Justice. Can you hear me? Can the court hear me?
I can hear you. Yes.
Thank you. Thank you. No, I was giving a lawyer's answer, which is you're getting it right and wrong, Justice Mlechi. But let me explain why I'm saying that. You have very correctly alluded to the dignity right, which we do invoke in our regulatory framework. You will remember that we talk about Section 10. And I'm sorry, I've just lost that place now. It was paragraph, I'm helped by you, Justice, is paragraph 135. Remember, we were doing the regulatory framework.
Yes, yes.
It says everyone has inherent dignity and the right to have their dignity respected and protected. And then we put there in brackets plus the right to work. Now, what you meant by that is exactly what you were saying, Justice Mlechi, that it was said by Justice Nugent in the case called Wachenuka, Minister of Home Affairs versus Wachenuka. It's one of our cases, paragraph 27 of that case. It was also said by Justice Sachs in Masetla that Justice Sachs, putting it in his usual flowery language, says that an employee does not live by bread alone, meaning that it's not just the money. There's also the right to dignity and self-worth, which goes with work. So when you are suspended or expelled, someone is also affecting your right to work, your right to self-worth. They might be paying you, but I know you're familiar with that. Yeah.
Yes,
So
it's words that come from Lord Bederbent.
Yes.
In each case, yes.
Yeah, absolutely. Thank you. So so we do assert it. That's why we put those brackets, the right to work. But you're also right, as I'm saying. That's how I was saying you are wrong and you are right. You're also right that the heavy accent of our attack is not so much on that. It is on the right of participation, the Section 19 rights as the SG. But we certainly do not assert the right to work. We actually do in so many ways as well. So both as an employee and as a member, his Bill of Rights, if there's such a thing, Section 19 rights and Section 10 rights were limited, infringed, violated, whatever you call it. There's no doubt about it. And that then cries out for a Section 36 justification. So there can be no doubt in anybody's mind that his Section 10 rights, his Section 9 rights, we will also argue, that's the right to equality, to be treated equally, are abrogated. But here's the thing, and this is what I was coming back to Justice Kolapen. Assume for a minute that we were in the Bakhazian world. Even as a contractual right, forget the Constitution for a minute. Even as a contractual right, the ANC Constitution in Appendix 3 thereof, which you'll find at 003-102. And again, this is why our learned friends have to come up with the linguistic gymnastics of saying this is not a disciplinary measure when it clearly is, because it's in clause 25. Because they are running away from this. If it's a disciplinary measure, then it must be treated like all other disciplinary measures. And then it attracts what in the ANC is called the Big Five rights of members. and it says that if it's any disciplinary proceedings, there must be a formal procedure, 1. 2, there must be a just and fair procedure, that's the Audi. Okay, so Audi not coming from the Constitution now, just coming from the contract. 3, a member is presumed innocent until proven guilty. So the presumption of innocence is also not only premised on the Constitution of the country, but on the Constitution of the ANC, which is the contract. 4, a member has a chance to defend herself or himself, that's obvious. 5, a member has the right to appeal. So the right to appeal, you don't only have to source it in section 34 of the Constitution. You can even source this from this contract. So this, as I say, assume this was 1981, there's no Constitution. If the Constitution of the ANC gives you these rights, then they have been breached even as a contract. But to make it worse, those rights also appear in something called the Constitution of the country and the Bill of Rights. So on either count, whether contractually, even if this argument, which really is perplexing, that no, this is just a private thing between a member and the ANC, I mean, which is really just, I don't even know if I have to address that. But let's assume that that was true, that this was just a private contract. That private contract gives you these rights, and those rights have been breached even at that level. So either way, and that's why the justices in Ramaphosa spoke about the interplay between the ANC Constitution and the contract itself, because those two things go like this. At some point, you can't say I'm now breaching the contractual right. If you are a political party, you are breaching that contractual right in the milieu of its constitutional existence. So the two things are not separable, but conceptually, obviously, we can separate them and say, now let's focus on the contract, now let's concentrate on the Constitution. But in reality, there's an interplay between the two, which is symbiotic and cannot be dissected. But I'm saying even if it was dissectable in this case, this way, you turn left to the Constitution of the country, you'll find the requirement of Audi. You turn right to the Constitution of the ANC, you'll find the Audi, and it has been breached. So, yeah, I'm sorry, just 1 second, please, just so that I finish this thought. Yeah. At paragraph 27 of Wachenuka, it says the following. Just to finish the issue that Justice Mulahleli said, raised. The freedom to engage, this is Justice Nugent, JA. The freedom to engage in productive work, even where that is not required in order to survive, is indeed an important component of human dignity, as submitted by the Respondents' Council. For mankind is preeminently a social species, which with an instinct for meaningful association, self-esteem, and a sense of self-worth. The fulfillment of what it is to be human is most often bound up with being accepted as socially useful. And then it says, and then it goes on. But your Justice Mulahleli even found, I'm sure, even a more flowery source from the Lord himself. Sorry, Justice Kolapen.
Mr. Mpofu, I just wanted to ask you this question, and if, in your view, it makes a difference. So the suspensions that are provided for and the fair process guarantees in the appendices are all in the context of a disciplinary hearing or the contemplation of a disciplinary hearing.
Yes.
25.70 doesn't appear to contemplate an internal disciplinary hearing because it relates to an outside event, as it were, a charge by an institution. And I know you've made the point that we should be careful how much of weight we attach to the charge, but leaving that aside, there's a jurisdictional requirement that you have to be charged or indicted, and therefore there's no contemplation that there will be a disciplinary process. There's a contemplation that there will be an external process disconnected with the ANC really, because they don't manage the prosecution, and the suspension will endure until your name is cleared. And the principal consideration in the suspension is the interests of the organization. That's does that place it on a different footing in your view, or in your view, does the fair process procedures apply with equal force?
It applies with equal force, Justice Kolopen, and I'll explain why. Firstly, of course, we reject the notion that this is not punitive. And let me just say this so that I'm not misunderstood, Justice Kolopen. The character of what is contemplated in 2570 is twofold. That I will concede. One, and this is if anything else I'm going to say today it must be appreciated, it is this. There is a component of the 2570 regime which is voluntary, or even the step-aside regime itself, voluntary. Now, I'm the last one to stand here and waste your time by saying that when you are exercising the voluntary part of this regime, you must be given Audi. That would be nonsensical, because it's just, it follows. Where we part ways with our learned friends, and we accept unreservedly that insofar if a member is driven by conscience and all those things and decides to step aside, that's fine, that's their prerogative. But once you introduce the element of compulsion, once you say, well, if you don't step aside voluntarily, now you must be suspended, then you are in a completely different world altogether. You are in the world of punitive measures. So it doesn't matter that they say, okay, well, if you leave voluntarily, we'll give you a bag of oranges or whatever. That's fine. That's got nothing to do with us. But once you cross the Rubicon, once you cross that line, that that now goes into compunction, and you are now told that you must leave, pack your bags right now, and you will not address any meetings, you will not go to branch meetings, you will not, what are all the things that are said there. Then you are in another world. And in that world, unfortunately, Audi is a player. In the first world of the voluntary aspect, Audi is not a player. That's the, I'm sorry, Justice. I'm sorry. No, I just wanted to say upfront, I always say this, particularly if there are three judges. These electronic things, it might sometimes looks like we're speaking over each other, but so that's why when I say that someone is trying to come in, because you have a right to interrupt me, but I don't have the right to interrupt you.
Yes. I'd like to follow on from Justice Kolopen's question in this sense. One has to look at the history of 2570 and the history of the step-aside resolution. Right. So in 2020, there were guidelines developed. Mm-hmm. And those guidelines was that anyone accused of corruption must go to the Integrity Commission.
Yes.
If no reasonable explanation is shown, then he can be suspended, and the step aside, and that might lead to the either voluntary or suspension. Now, in the context of this matter, he was charged, and he was advised, or everyone was advised, those who'd been charged criminally, that they had to go to the Integrity Commission. He goes to the Integrity Commission. He says to the Integrity Commission, and is this not part of Audi is my question. He says to the Integrity Commission, if you find that these charges mean that I must step aside, I will voluntarily do so.
No, Well, firstly, I'm sorry. That's not what he said. I'm sorry if I don't know. Let me wait for you to finish, Justice.
Okay. Well, he basically said, if I remember correctly, that he committed to stepping aside if
the NEC.
If the NEC, yes, okay. So is your argument now that the NEC never said he should step aside? Because it appears that they did, that the suspension letter was written on the authority of the NEC.
No,
so,
no. I'm sorry, Justice Winner. Not even the respondents argue that they say it was done on the basis of the NWC, but I'll explain the difference just now.
I'm sorry, I know the difference. I'm just saying that it was authority down the line that anyone accused of corruption must go to the Integrity Committee, which he did. He went to the Integrity Committee and they found that they didn't accept his explanation, or they found that he should step aside. They then advised the NEC, and he said in the Integrity Committee meeting that he would step aside if directed by the NEC. So is your argument that there was no Audi, or that this amounts to some sort of Audi, but the NEC didn't direct him to step aside?
Okay, it's both. It's both, Justice Winner. Let me explain. Firstly, believe me, I will come to your question directly. But let me first explain to you why, first of all, that discussion is irrelevant to the first issue of the constitutionality or otherwise of 25.70. But I will entertain it in the context of what Justice Mulathei was saying, the actual implementation, in other words, in this case. As far as the constitutionality of 25.70 is concerned, what we are busy with now is completely irrelevant, because if it's either 2570 was unconstitutional when it was inserted, whenever it was inserted, or it is not. So it can't be cured 5 years later by some letter or whatever. So the criticism of 2570 per se has got nothing to do with what happened in this case. It's got all to do with what Justice Kolapen calls the textual four corners of 2570. Okay, so let's put that aside and then come to your question. What we're talking about here, firstly, you can't have Audi in front of another body. Like you have Audi, you're going to be fired by the Johannesburg Council, but you get Audi in the Port Elizabeth or Gqeberha Council. Audi must be with the body that is the decision maker, firstly. Secondly, the Integrity Commission stage. Let's assume for a minute that as far as the Integrity Commission is concerned, there was Audi at that level. In other words, he's not complaining that the Integrity Commission did not give him Audi. That has absolutely nothing to do with the Audi in front of the suspending body, which is the NEC or NWC. And here's the important thing, Justice Wayner. It goes to the question of legitimate expectation. Remember that Audi also comes by way of legitimate expectation. Because this thing we call legitimate expectation is shorthand for legitimate expectation for a hearing, right? Now, this is what actually happened in this particular case. The NEC, as we say, unlawfully doctors the resolution, and then even on its own terms, they then say you have 30 days to step down. let's assume then that's the authority that you are talking about, the authority of the NEC. But what do they do at the end of the 30 days? They say, Mr. Mantashe and Mr. Pule are asked publicly. Well, the 30 days is over now. Aha. So does that mean the SG is automatically suspended? Mr. Mantashe says, takes it as an insult. Say, this is a very serious organization. There's nothing automatic here. We have an NEC, and the NEC is going to process this matter. In other words, the applicant says to you, to this court, that I had a legitimate expectation that I'll be given my Audi at the NEC to report back on my consultations with the leaders, with President Mbeki, President Zuma, former Deputy President Mohlante, former TG Posa. That's what they say, and that's what he expects is going to happen, that the Audi is going to be on Saturday, the 8th of May. To make it worse, they then invite you to reinforce that legitimate expectation. They then invite him to a meeting on Sunday at the home of the president, of President Ramaphosa. These 2 days after the 30 days has expired. To make it worse, they invite him again on Monday the 3rd to the meeting of the NWC. This is all common cause. To make it worse, on the even after the so-called suspension letter has been issued, Ms. Jesse Duarte, the author of that letter, calls him to say there's going to be regional conferences in the Northern Cape. SG, please come and authorize them.
Can I just stop you there on that point? Doesn't she say that the reason she did that was because the applicant had instituted review or appeal proceedings or was noted, and therefore she felt that in some way suspended the suspension? Yes,
very good. On that one, okay, firstly, that doesn't explain the other things I've just spoken about. The invitation to the NWC and the officials meeting and the statements of Mr. Mantashe and Mr. Pule. But let's then come to that one. The one of the acquiescence or condonation or estoppel, whatever you want to call it, or waiver, the one that deals with the Northern Cape. This is how it works. She says, and in fact, if she says what you are saying, Justice Wena, we will clap hands, because we will say, oh, thank you, because that again reinforces our case on the right to a hearing. Because if she asked him to sign the Northern Cape documents on the understanding, remember, she's now, according to this new 16.9 interpretation, she's now the de facto SG. So if she, as the quote-unquote SG, says in the name of the organization, your suspension has been suspended because you have submitted a review, then that must be taken to be the stance of the ANC. And if that is so, that means when your review is going to be heard on Saturday, you will be heard. So there's no escaping the Audi point, I'm afraid. So if that is the case, then that would explain why then they invited him to the Women's League meeting on the Friday. That would also explain why they invited him to the NEC on Saturday, only to boot him out and humiliate him. But it would not explain why they booted him out before hearing him. Because that is the 8th, the Saturday the 8th is the day at which, according to everybody's theory, whether it's the Mantashe Pule theory, he was going to be heard at the NEC, or whether it's the Duarte theory that Justice Wayne is putting to me, in other words, that the suspension is suspended, he's still going to be heard on Saturday. And both of those things did not happen. There is no doubt, there can be no doubt in anybody's mind that he was not given a hearing before the NEC, which is the body that clearly had to take the final decision, let alone the issue of seniority and all that. But the fact that to suspend a Secretary General, I mean, there is a document which was submitted. It's called Annexure B or something to the suspension letter. That document is submitted by the Treasurer General, my lords and my lady. You'll find that it's an annexure to. You'll find it at 001-96. It's called Attachment B. This shows you the absurdity of what was done there. This document has got something called the proposed terms and conditions for the participation of members elected office bearers and public representatives who have stepped aside voluntarily. And then you'll see that it also deals with those, with all step asides. And then it gives you the conditions. If you go to 001-98, you'll find that there's a mirror image of the conditions that were given to the Secretary General. You may not occupy executive office, not represent the organization publicly, not make public pronouncements, and so on. So what does this mean? It means even the step-aside regime itself had not been yet formulated properly. This is proposed. These things were proposed to be adopted at the NEC of the 8th of special NEC of the 8th of May. So how do you suspend someone using rules that are still going to be endorsed? And so you've suspended them how? With retrospective effect. I mean, that's a breach of the rule of law apart from anything else. Yeah. So it's just a mess. There is no way that the Audi could have been satisfied. The least they could have done, Justice Winner, we should have neutralized both what I call the J.C. Duarte theory of suspension or the Mantashe theory would have been to say on the 8th, okay, thank you. You are here now, Mr. SG. Just tell us why you should not be suspended. And then he would have said whatever he wants to say. And then they would have said, no, despite what you are saying, you are suspended. Or, which is more realistic and more in line with what Justice Weiner is putting to me, all they should have done is to take out SG 8, which is at 001-100, and say, you have now given us 12 reasons why your suspension is unlawful. A dozen. We'll call it the dirty dozen. 1, they failed to rely on they relied on the incorrect, inapplicable rules, and so on. Number 2, the decisions were made by incorrect and incompetent persons. Number 3, they mixed up relevant provisions purportedly being invoked. Number 3, they backdated the letter. Number 4, it was premature because the special meeting of the NEC had not yet taken place, the point I've just made about Annexure B. 6, failure to afford the opportunity to be heard as to why suspension should not be imposed. 7, unfair, inconsistent, and selective factional application. 8, invalidity of the so-called step-aside regime. 9, the failure to refer the specific matter to refusal or failure to step aside, and so on and so on. And number 12 is ignoring the opinion of Mr. Posa. They could have just said, okay, we're going to look at those 12 things that he has put. Let's forget about Audi in the normal sense that he must be here. We're still going to boot him out. But at least let's listen to his representations.
Sorry, Mr. Posa, can I just try and get some clarity?
Yes.
The point you make is that Audi must have occurred before decision to suspend, correct?
Correct.
So it wouldn't have helped to have afforded him Audi on the 8th if the decision had already been taken. And it would have been argued that, well, the decision is cast in stone. It's water under the bridge. But you could be reviewing or appealing it if there was such a right of review and appeal. So is the issue not quite simple? Firstly, was he entitled to Audi before the decision was taken? If he was there Audi? If he wasn't, that's the end of the matter. Secondly, once the decision is taken, you can't have Audi after that. You can possibly have an appeal or a review if there is a right of appeal or review.
Yes, no, Justice Koropen, we're exactly on the same page. I'm talking about 2 Audis. That's why I said even if you accept the Jesse Duarte suspension theory that Justice Wayner was putting to me. So I was saying, even if you accept that, in other words, you say the only reason she invited him to do the Northern Cape letters was because there's a pending review, right? Then it's the Audi number 2, the one that you are postulating. In other words, even for that review only, let's assume all the other problems. Remember, when he says at 1.7 of his letter, the unfair, inconsistent, 1.6, failure to afford the opportunity to be heard as to why a suspension should not be imposed. There he's complaining about Audi number 1 in your example, the one that must happen before the decision. But I'm saying, let's forget the Audi number 1. Let's go to Audi number 2. Say, okay, that's water under the bridge. You are now doing a review. You need your Audi in the review itself. And I'm saying even that Audi was denied. So 2 Audis don't make a right.
Don't make a Mercedes, okay?
Yes. Yes. Okay. Yes. So can I move on from this point then? Because I think it's clear that, in fact, it just gets worse for them, because now it's clear that there are 2 Audi opportunities that were denied. Right. Now, the point about our approach is the following. I say again, 2570 is unconstitutional, capital letter C, because it breaches the constitution of the country. But I say it's unconstitutional, small letter c, because it also doesn't afford the rights that are afforded even in the ANC constitution of presumption of innocence and so on. So let's put that aside. Those are our submissions. Three grounds: no Audi, presumption of innocence, and right of appeal. Not because it's a suspension per se, as it was alluded earlier. So let's say we're wrong then on that. For some reason, sorry.
No, I thought you included also the fact that 2570 is silent on the right to Audi.
Yes, absolutely. Yes, I did. But I'm saying, Justice, that is in the first leg of unconstitutionality per se. Yes.
But you see, on that point, Mr. Mpofu, I don't know whether you've ever looked at the South African Police Act, because I think
a lot.
Have you? Because somewhere, I think section 26 or section 46 or 36, somewhere there, it talks about suspension. And quite interesting, because the formulation is very square, and I'll call it this way, to say the disciplinary hearing is outsourced in a sense, in that if you are a member and you are charged with a criminal offense and you're convicted, you automatically dismiss. So the police do not undertake disciplinary procedures as we would anticipate them. And similarly here, as I see it, you are suspended pending the outcome of a court hearing. But the point I wanted to make, when you look at one of those sections, you'll see that it actually doesn't expressly state anything about being afforded a hearing before that suspension happens.
Yes. Okay. Yes. No. I know the section. I've dealt with that section. Firstly, it's as follows. That is a statute. Now, that statute, that's why we talk about section 36. When section 36 says you can do certain things, you can violate quote unquote, the rights of somebody subject to a law of general application. The South African Police Service Act is a law of general application. So it falls squarely into the Section 36, yes. And why is it so? Because that law is, it might be because the police are essential services or whatever. So there's a justification. But so in other words, if one policeman tomorrow can be suspended under that act, and then he says, or she, I'm contesting my suspension like we're doing now. I'm contesting my suspension on the basis that that Section 36 or whatever it is unconstitutional. Then the answer that the Minister of Police will say is yes, which I expected to happen here, will say yes, we accept that the suspension is punitive. Yes, we accept that it takes away your right to work. Yes, we accept that it takes away your right to dignity. But we have a law that, and then there'll be what is called a Section 36 inquiry as to whether that law itself can withstand all the 5 tests in Section 36. If it does, then the policeman must be suspended. If it doesn't, then the policeman must be reinstated. So it's exactly the same thing here. If 25.70 is not justifiable, then the SG must be reinstated. If it is justifiable, then he must stay suspended. It's that simple. But here we're dealing with a clause rather than a section in a statute. So it's slightly easier, let me put it that way, for the SG than it would be for that notional police person. So I was just saying, I want to move through this quickly because we've canvassed it. Assume then that we are wrong on that 2570 somehow miraculously survives constitutional scrutiny, both at the level of the ANC constitution and at the level of the constitution of the country. I don't know how, but let's assume we're wrong. Then there is no doubt from the debate, I won't belabor the point because the debate with the bench has made it clear that then even in that case, Audi was denied twice. So it really doesn't assist anybody even if you interpret it generously to say Audi is only implied and therefore you don't chop it out. Yeah. But if we are right, and with respect, we are confident that we are, that 2570, as Mr. Posa said, that there's no real regime to implement the step aside rule, if you really think about it, and certainly 2570 is not it. If we are right about that, then that is the end of the case as far as the suspension of Mr. Magashule is concerned. Because why? Why do you even go to the letter? Because the letter specifically says that it is invoking 2570. 2570 will be gone now, so that's the end of it. Why even go to Justice Winner's example of the Integrity Commission? Remember, the Integrity Commission also said you must invoke 2570. So it would mean that they were also saying you must invoke a nullity. And by the way, the Integrity Commission did not say that, well, firstly, the SG did not say to the Integrity Commission, I'm going to step aside. He said that according to the Integrity Commission themselves, sorry. Can you see? 1-4. No, it's an hour. Okay, let me paraphrase it so that we don't waste time. What he said is that if the NEC asks me to step aside, I will do so willingly or whatever, as I say, I'm paraphrasing. Now, there's a big word that keeps on being forgotten in the heads of I've inserted it about 20 times in the heads of the other side. That word is lawfully. If we forget that word, then we're out of this. So when the SG says, if the NEC asks me to step aside, or he's all he's saying is that if they lawfully force me to step aside or whatever, and you will find, I will deal with this maybe in reply as well. There's so many instances where that word is conveniently forgotten, and you'll find it. It's SG. I don't know the SG4, but the
letter. Are you looking for the letter, Mr. Mpofu?
Yes, the letter from the IC, from the Integrity Commission.
00164.
00164. I'm indebted to the court. Yes, it starts at 63, but the actual text is on 64, and I'm referring the court to 66, 001 66. Oh yes, yeah. It says in his interaction with the IC, the Secretary General indicated that he will never resist the decision of the NEC, even if he might not agree with it. However, in the unlikely event of resistance, the NEC, underline that by the way, is the NEC, not the NWC, should consider suspension pending the finalization of the criminal case against him in terms of Rule 2570. So I make 2 points. 2570, if it's unconstitutional, it means that whole thing just flies out of the window. But assume for now that 2570 survives. Then what he's saying is that he will never resist the lawful decision of the NEC. So if the NEC takes a decision which is susceptible to 12 legal challenges, as we have shown now, you can't hang. It's like me saying, look, if I'm arrested, I will go to jail. I don't mean that a policeman must just come and grab me, and beat me up and put me in the boot, and then I say, oh well, but you said, Mr. Mpofu, you'll gladly be arrested. Once they overstep the mark of the law, then all undertakings are off.
Mr. Mpofu, can I ask you this question, please? And it doesn't relate to the specific point you make, but yeah. It's just something I'm thinking through in characterizing the dispute and locating it within both the character of the organization and its relationship to the Constitution. It seems that we have an organization that at least constitutionally is committed to certain values, collective decision-making, internal discipline, the spirit of voluntariness.
Democratic centralism, yes.
It also seems that the organization functions at different levels where at some instances its persuasive powers are used, and in some instances its coercive powers are used. And there's an interplay between the persuasive and the coercive. Okay. At some levels it functions, and preeminently so, at a political level because it's a political organization. And at other levels it must function within certain legal constraints and legal disciplines. What, if any, is the interaction between what may be conflicting paradigms, or is your sense that, well, ultimately, in the context of this case, one must simply look at the right of this individual, and if the right's been violated, vindicate the right, and the interests of the collective, as reflected both in its founding documents, but also in its working methods, don't matter. And that relates, in a sense, to the engagement with the Integrity Commission, etc. Because there appears to be two processes that run maybe on parallel tracks. And do they ever converge, or ultimately is it the individual's interests that carry the day?
Yes, I understand the question, Justice Kolopen. I will refer you. I'm just looking for the paragraph. it's also cited in our heads. The utterances of Justice Yakub in Ramakatsa. You will find that at paragraph 50 of our heads, where it refers to, it's paragraph 16 of Ramakatsa. Justice Yakub said, and on this he was speaking for the majority, even though his was a dissenting judgment. I do not think that the Constitution, capital letter C, of the country could have contemplated political parties could act unlawfully. And if I can put in brackets, that means breaching Audi as well. On a broad purposive construction, I would hold that the right to participate in the activities of a political party, that's the right in section 19, 1B of the Constitution, confers on every political party the duty to act lawfully and in accordance with its own constitution. And here, this is the punchline. This means that our constitution, capital letter C, gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership of that party. Exact compliance, right? So what it means is this. Firstly, a political party is not just a football club or some voluntary association to which I might belong with my friends. It is, as Justice Musanega called it, the veritable institution and conduit through which citizens express their political rights. And that is why this notion that we're dealing with a contract as if I'm buying shoes at the mall is laughable. You are dealing with public rights, an institution that exhibits, and Justice Cameron said this, albeit in a minority, in the case of My Vote Counts. He says that the rights there's this debate about whether, and I'm sorry to take this detour, I'm coming back to the question, Justice Colopen. But there's the debate, Justice Colopen, about whether PAJA applies to political parties. It's an age-old debate. It's been going on since Rabakata until now. It was referred to in the Delil case. I appeared in that case, and we tried our luck with it in Ramakatsa first, as you can see. What we did there in Ramakatsa, we pleaded out the contract, the constitution, and PAJA. And Justice Musaneke and Justice Jafta said, because they found in our favor in respect of the first two, it was not necessary to deal with the PAJA point. So they dodged that bullet that way. Then in Delil, the same thing was said. Our main attack was PAJA, and the court gave a very flattering assessment of our effort there, but it still said, is this it? No, this is the wrong one. Okay. I'm sorry. Anyway, in Delil, they said the same thing. In a case called no. I'm sorry, if the court can just bear with me. my vote counts, which is the one I was referring to, I think it's paragraph 38. No, that's the wrong thing. I'm sorry. This was referred to by the Constitutional Court in my vote counts. Firstly, the court made the point that political parties, the contracts at 129 of my vote counts, the following statement is made. Political parties are neither public bodies nor private. That's the culmination of the debate by Cameron J. And he does that by making an assessment of Ramaphosa and also of the Cape cases, let me call them that. Those Cape cases, it's a case of National Party versus Van Zyl and two others, which dealt with this Paja point. And the point I'm simply making is the following. And I'm addressing two points at the same time. Firstly, this point which is made by the other side, that this is just a private affair. It can never be. Oh, this is the following. This is what was said in Delil, and the full bench at paragraph 29. Oh, sorry, let me give you the citation, because the one that is in our list is wrong. It's the wrong Delil case. This one is 2018, volume 3, all SA 684, WCC. It was a full court decision of Justice Lehransi, Mantami, and Sheh. And they said, it will suffice to point out, as was done by the Supreme Court of Appeal in Calibre Clinical Consultants, which is another important case, by the way. If I can give you a reference to that case. It's 2010, volume 5, SA 457, SCA.
Just give me that again, Mr. Mpofu. 2010?
Yeah, 2010, my lord, bracket 5, SA 457, SCA.
Thank you.
A very important case as well in terms of the of this point about Paja. It was said in the SCA said some recent decisions of the High Court in this country reflect a more expansive approach, but they are not always consistent. The question whether the conduct of a political party is susceptible to review evokes varying responses and so on. And then it quotes Marais versus the DA, Van Zyl versus National Party, Max versus the Independent Party, and so on. And in Delil, it was said that the question of whether or not the conduct of political party is susceptible to review on the grounds that it constitutes administrative action has, quote, evoked various responses. They were quoting the SCA. In this division itself, there are what appear to be conflicting judgments. See, for example, those cases that I've already read out. We may point out that in Marais, Hlophe, JP, and Van Zyl held that a decision to remove a mayor of a large city did not necessarily constitute exercise of public power or the performance of a public function. Every case had to be decided on its own terms. And this is the flattering part, which when they don't agree with you, as enticing as it may be to enter the fray and as attractive as the arguments which were advanced by Delil's counsel might be, we are satisfied that this is not the appropriate occasion to attempt once again to decide this issue. Our reasons adopting this stance are as follows, and then it goes on. So again, the issue was dodged, quote unquote, with respect in Delil. But the point I'm simply making is that the fact that those courts in Ramaphosa, actually, if you look at it, even the dissenting judgment of Froneman J. Ironically, actually, Froneman J was criticized by the other judges because they said he only considered the review grounds. He forgot about the constitutional and the contractual ground. So all the justices on either side of the Ramakatsa case either accepted that the review that Paja applied or say we're not prepared to entertain it. So I'm just saying there's no clear-cut issue about the public nature of this contract as the respondents would like this court to be.
I hear what you're saying, Mr. Mpofu, and lest we get accused of dodging the bullet in the future, I don't understand that the case you're advancing today is to invoke Paja. I mean, that's not the case. That's not the case in the papers.
No. But the case I am advancing, and which is very important, Justice Kolapen, is that it is a fallacy to say that what we're dealing with here are private rights of the shoemaker down the road. As I said, twice beaten, thrice shy, if there's such an expression. I tried it in Ramakatsa, I tried it in Delil. I was not going to try it again here. Okay. So this case is not dependent on a Paja ground, no. But we reject strongly the notion that it is that it doesn't invoke public powers. It does.
Yes. Sorry, Mr. Mpofu, I don't want to unduly interrupt you, but I'm not sure what Ms. Cello has to say because you are eating quite a lot of her time up now.
Well, I'm not eating alone. The court is interacting. So I think we're all eating into her time with respect.
I just thought we do an assessment as to where we are and
I understand. No, I understand, Justice Kalapan. On a serious note, we are at 4:45.
Judge Kolapen, can I make a special plea? Take a 5-minute comfort break.
Yes, and then can I take advantage of that and answer you when we come back, Justice Kolapen?
Yes, no, I can. Maybe I thought you were referring to me, but maybe I can tell you what I wanted to say to you about Ramakatsa. If you look at paragraph, not even something to think about, but I want to say I don't understand paragraph 5 of Ramakatsa to be saying that it draws a distinction between private as in political and voluntary associations. As I understand it, it gives a blanket coverage of saying private or voluntary associations are also covered. And somewhere in the last sentence, I think that's where it says the contract of members are unique. So it doesn't exclude all private, it doesn't treat the voluntary association membership as a contract as being different to any other contracts.
No. Justice Mulathi, I agree that that's what I called earlier the interplay. We have to understand there's a difference, a huge difference between, if you read Ramakatsa, between the constitution of the Houghton Club, which I might belong to, and the constitution of a political party. That's the only point I'm making. Okay, of course, Ramakatsa says that that's why Ramakatsa draws from the Jockey Club cases, because it doesn't reject the notion that voluntary associations are by their nature bound by the rules of natural justice. But it says when it comes to an entity that is ruled by the Constitution under Section 19, you have a sui generis contract because of that interplay. So it's not like any old voluntary association. It is a voluntary association which is a political party.
Okay, the other little point just before we break is, Justice, when I asked you a question about in relation to the OD and the IC, the Integrity Committee. Now, I was just rereading the last paragraph of the sentence, and I just want to make sure I understand your argument. Yes. Your argument is basically, and it seems to come out on that last paragraph of the letter, The IC seem to be saying, we've listened to you, we think you must go back to the NEC, and it's for the NEC to then decide, to consider suspending. And your argument is, it couldn't have, that could not amount to a hearing, because even on their own report, they are referring him back to the NEC, and it's for the NEC to then make the decision on the suspension. Am I?
Yes.
Okay.
Absolutely. And actually, to be fair, the Integrity Commission seems to be the only body that understands 2570, because they were right. Even the NEC would have to consider. There is no such thing in this world as somebody saying 2570 must be invoked. That's just a misnomer. 2570 itself is discretionary. It says even the SG may suspend you if it is in the interest of the organization. So there's no one who has any right. It doesn't matter if they are whatever their name is, or the king or the queen of England, who can say the 2570 must be invoked, which is what happened here. So that's another reason why you can't. It's like changing the word may to must. Nobody, that's ultra virus. And unfortunately, Justice Mulathi, the Integrity Committee knew its limits. That's why it said even the NEC must consider, number one. Number two, this also shows that the real body where the Audi is supposed to happen is at the NEC, which is the point I made earlier to Justice Weiner. Thank you.
Okay, good. Shall we take a 5-minute comfort break then?
Thank you. Yes.
And when we come back, Mr. Mpofu, maybe you'll just assist us with regard to the rest of the day.
I will. I'll negotiate with Ms. Cellular.
Okay, thank you. Court adjourns then.
Thank you, my lord.
Okay. Are we back, Mr. Mpofu?
Yeah. Oh, sorry. Yes, I'm back, Justice.
Okay, Mr. Mpofu, let's can you indicate to us how long you will still be, given that it's about 5 to 4 now, and whether we'll still then conclude the applicant's case today, and if we do so, at what time will that be, and how much of time Ms. Cello might need?
My Lord, Ms. Cello has indicated that if it's okay with the court, because we also appreciate the interactions with the court, we think they are crucial, that she is prepared to start tomorrow on her section, and we will talk to the other side about the implications of that. As far as I'm concerned, I can...
How long will Ms. Cello's section take?
Well, she had said to me it was going to be 45 minutes, but counsel, I'm sure the judges know that counsel's estimations are, so I would say, but I don't think it will be more than an hour.
And how long?
Depending on the interactions with the bench, of course.
And how long will you require to conclude your part today?
I can conclude at 4:30 if I'm just speaking. But I'm not discouraging the court. But if the court does, let me put it this way, seriously, Justice Scorpion. I can certainly conclude by 4:30, but I will leave it in your hands. You will assess if there has been robust interaction. Then you can give me grace of 10 minutes or whatever. But I can conclude by 4:30.
Okay. Look, I think the interaction has been robust, and yes, I think, and I'm not blaming you for this, but I think that we might be traversing ground that we've already traversed in the interaction. So maybe we all need to just bear that in mind and work towards a 4:30 finish.
Yeah.
We'll hear from Mr. Trengove what that means with regard to the respondent's case, because if we start at 9:30, the respondents will only come on at about 10:30, and I want to ensure that he has enough time to conclude his argument and leave you some time to reply. Mr. Trengove?
Yes, I want to afford my learned friend every opportunity, but we must insist that we be given an equal amount of time. Okay. My learned friend knows about a fair hearing, and a fair hearing would be at least equal time for the two sides, so that we must just know that they've already taken 3.5 hours. There's another half an hour, it's 4, another one tomorrow morning, that's 5. 5 hours from then will take us to the end of tomorrow.
Yes, well, okay.
Perhaps may I suggest that we start at 9 tomorrow? I don't know if anyone's got a problem with that.
We'll be happy with that. Yes,
9 a.m. is fine. And then, Mr. Mpofu, we're gonna work until 4:30, and then work towards a 45-minute address tomorrow from Ms. Cello. So that,
well, give or take.
We'll keep you to your estimation, and then we ensure that we give Mr. Trengove the fair time as well, in accordance with the time that your team has taken. Yeah. And we'll conclude tomorrow, though. We have. Yeah. But
yes, Mr. Magashule is prepared to give the ANC a fair hearing.
Okay. Well, we'll conclude tomorrow, but not tomorrow night. We have to conclude at a decent time tomorrow as well. Okay. So.
Thank you.
Okay.
Thank you. I appreciate Leonard Friend's cooperation and the court's indulgence. But if I may then move on, I'm now moving to 2 topics that, so even if we come back to what we are discussing now, we will, if there's time, but there are 2 topics that I really have to deal with. But to round off just the point we were making now is that the 2 principal defenses, if you can call them that even, that have been suggested, is one, that this is a private shoemaker type of arrangement, which it is not. And the second one is that this is It's not. It doesn't. It's not disciplinary. That 2570 is not disciplinary or punitive, which is also really doesn't deserve much time.
And you've dealt with both those in your
I've
argument.
dealt with both of those, yes. So the issue then, if we go back to the resolution, I just want to talk about the issue of the repurposing. And then I want to talk about the issue of, assume I'm wrong in everything I've said today, the fact that 2570 on its terms was not complied with in this particular case, even if everything I've said about Audi and what have you is wrong. So let's start with the repurposing. We accept that, and as Justice Wiener put it to my learned friend Ms. Koffer in the morning, that the issue, or rather issues of renewal and factionalism and all that background is relevant to the extent that, and that's why Ms. Koffer had to make that concession to say, even if the issue itself of the CR17 is relevant, but it doesn't mean you must now attach a judgment, which is a waste of time, and the whole public protector's report and all that. Yeah. So we're the last ones to say the court must just get into the law without the surrounding circumstances. That is why in the founding affidavit we even went blow by blow so that the context is properly understood, and it was for this reason. Motive, as we know, is not all decisive in these matters, but it is relevant. So if, for argument's sake, the NEC repurposed or amended the NASREC resolution for the most benevolent reasons, because they want to save the world, it would still be wrong to do that, because it's a matter of law that the NEC does not possess the powers to amend the decisions of National Conference. Right. So I want to put it out there so that I'm not misunderstood when we get to the true motives in this. So the legal point is a crisp one, which is ultra vires, or irrationality as it is known these days. Or the principle of legality. And it simply says that if the National Executive Committee constitutionally does not possess the power to amend a conference resolution, and it did so, then it becomes, and I don't think anybody around the room will contest the fact that the NEC does not have those powers. We, even my learned friends, will accept that. What they will argue is what I'm going to get into now, which is, in fact, was there an amendment of the resolution? So that we can quibble about. But the fact that the NEC has no virus to do it is trite. So let's look at it. And because of the time constraints, I'm going to take a shortcut. Forget the legalities and the words and so on. Just take one simple example. The National Conference says that the people who must step aside are the people against whom allegations are made, the people who are convicted, and so on and so on. And then it includes a category of those who use money to influence conferences. A very important issue, if Justice Collerpen, you are right that This is an organization that has certain values and so on and so on. And that organization itself draws the real line in the sand, not these pseudo lines that were drawn subsequently. It says, we are drawing the line in the sand on the use of money to buy conferences. Take me, fast forward everything we've said in the heads of argument and in the papers. Take me to the repurposed NEC resolution of 2020, which suddenly now talks about those formally charged must step aside, and then gives other so-called categories. That's what the defense says about this. They say, no, no, no. They were not repurposing it. They just were giving categories. Now, that's fine. Show me in those categories, where is the category of the people who use money to buy conferences? It's gone. It's gone. It's disappeared. Where the National Conference said that whether you have the criminal charges, and it says or disciplinary processes against you, or investigative powers. That you will find at paragraph 27. Paragraph 20, page 27 of our heads, where we quote the resolution. 2017 National Conference, paragraph 73. I'm sorry, I've just misstated my own head. I think it's 008. Yes, I'm sorry. I'm sorry. Page 27 of our heads is 008 145, dash 145. We've got it there. It says, this is what NASRAC says. They demands that every cadre accused of or reported to be involved in corrupt practices account to the Integrity Committee immediately or faces DC processes. Then it says, summarily suspend people who fail to give an acceptable explanation or voluntarily step down while they face, underline this, disciplinary, investigative, or prosecutorial procedures. The three categories. Take the doctored and repurposed NEC resolution and show me where it refers to investigative processes. So they've taken away two crucial things from the NASRAC resolution. The reference to stealing conferences by putting money, and it doesn't matter if it's 300 million or $1 billion. The mere use of money, whether it's 10 cents, to buy votes in a conference, a line in the sand is drawn. Gone, disappeared. Then National Conference says disciplinary, investigative, or prosecutorial. Investigative, gone. Why? Because there are people who must be protected in a particular faction, who are subject to the investigative procedures of the public protector, for example. So what must we do? Let's doctor what National Conference is. Let's profess and write affidavits here about how supreme the National Conference is. The president of the country respects the National Conference, wara wara. But when National Conference tells you which three categories must be in, you take out the one that affects you. Because you're saying so now let's make sure that public protector reports are not part of this. So how do you do that? You must excise, chop out those words. Let's make sure that NASRAC CR17 is no longer a stepping down offense. So what do? Chop out the National Conference resolution. In which world, my lords and my lady, is that not an fundamental alteration, repurposing, amendment of a supreme body? Where, as lawyers on both sides of the divide, when we talk about supremacy, we know we talk about supremacy of the Constitution. Now imagine if the Constitution said this: you shall have oranges, apples, and peaches. And then the legislature in Cape Town says, oh, you know, we just want to develop this constitutional provision, and it just requires oranges. Forget about the apples and the peaches. That would, anyone would laugh you out of court if you were to justify that kind of thing, because it would clearly be saying that you are not, and as I say, put aside the motive, the factional motives and what have you. Let's look at it coldly as lawyers and say, can a lower body re-engineer, repurpose, alter, vary, and amend the constitution of a higher body? The answer is a big no. And this is what happened here. What makes it worse is that it was done for factional purposes. Because when the NEC did this, or rather the conference did this, it wanted to root out corruption in all its ugly manifestations. But some people somewhere on Zoom decided that no, corruption must be rooted out in some manifestations that affect only a particular faction. That is wrong. There is no court that can tolerate, let alone condone, such behavior. And if that is so, my lords and my lady, then we have to accept that the re-engineered NEC resolution is a farce and is a fraud, and it is itself corruption against not Mr. Magashule, but against the delegates of the National Conference. There is a reason why those people are called delegates. They are not called people. They're called delegates. Why? Because they are delegated by their branches to go to Nasrec and spend 5 days and represent the million members of the ANC. If it was practically possible, National Conference would be a whole million people. But it's not practically possible, so you send delegates. And that is the highest body. When that highest body has spoken, there is only one way to correct it. It is not, when you are a supreme body, I'm sure even the constitution of the country is not God-made. It can be amended. And so can the constitution of the ANC. But that constitution can only be amended by the people who drafted it.
Okay, Mr. Mpofu, okay. I think we get that point.
Yes.
That
okay. So now let's get to the next point. The next point is this. Again, assume I'm wrong in all the 5 points that we have put, and I can assure you that I'm not. But let's assume, let's be nice, let's be benevolent. Assume I'm wrong. Then what we have, my lords and my lady, is that you have to then look at the 2570 on its own terms and look as to whether the ANC, in suspending the Secretary General, complied with 2570. I'm wrong in everything. 2570 is the best clause ever made in the whole world. What does it say? It says 1. The Secretary General, let's just stop there. The Secretary General may or suspend, what have you. Again, the delegates, in their wisdom or whatever you can criticize them, decided to give that power to an individual, a human being called the Secretary General, not to a structure. They knew that there were structures. The ANC has no shortage of structures, but they gave this to a human being called the Secretary General this power. Now, this power cannot be exercised, despite what the court has said to Mr. Mawere. The point of the matter is this: the Deputy Secretary General is not the Secretary General, and she may deputize in certain situations, but it is not an automatic thing that she just falls into place. It might well be. Let me give you an example. The officials, no doubt mindful of the fact that the Secretary General was compromised, let's put it like that, in relation to the step aside, decided to assign the running around, and I'm using that word with respect, around the step aside regime to the Treasurer General. We know that's why he put that Annexure B. That's the officials. They decided, we can understand that, okay, look, SG, you can do these other jobs, you can go and collect letters and so on. But when it comes to the mechanics and doing these guidelines, maybe it's not appropriate that you should be the person. We will assign it to the Treasurer General. They were sitting there, the DSG was there. They overlooked her and went to the Treasurer General. So who is to say that, assuming that the Secretary General was disqualified, which we have shown that he was not, because he was not suspended at that stage, but let's say he was disqualified by a so-called conflict. It does not fall, as she says in her affidavit, it just fell on me to write the letter. It doesn't work like that. Things don't fall from the air in an organization, in a constitutional state. Then somebody would have had to be assigned, and it could have been her, it could have been somebody else, but it does not fall on her to write a letter to suspend her boss, Nochal. I mean, where is that done? Let's assume this was a CEO of a country, of a company. The deputy CEO just says, "Oh no, the CEO is sick, so I'm just going to suspend him." Okay.
We hear that point, Mr. So the argument is that.
So okay, fine. Let's move. Yeah. So that's the delegation point. So there's no. This whole thing is being implemented by someone who has no authority. Then it says, in the opinion of that person, or if that person is satisfied, let's call that the satisfaction element. Again, it's a human being who must be satisfied, not a structure. Let's assume, again, I'm wrong. I don't know how many times I'll have to say this today. Assume the DSG had the authority. Then she must be satisfied. All right? But what does she say in her letter? The NWC has instructed that it is satisfied, that it is in the interest of the ANC. What? The delegates have said a human being called the SG, or let's be generous and say, or the DSG, must be satisfied. You decide that no, it must be a structure called the NWC. It must be satisfied. Where? Where can that be lawful? Then it goes further. It says that that person may then impose conditions. Again, here the conditions are imposed by, according to the letter, imposed by the NWC. So the fallacy that there's an implementation of 2570 is just laughable, because 2570 has been breached. Wherever it is now, it is in a casualty ward, because it's been butchered by the ANC, 2570, and reconfigured and made to look like something else for factional purposes or for holy purposes. I don't care. It could, whatever purpose it is, but the point is that it cannot be applied in this fashion, in this fashion. And 2570 says may, which means it's a discretion. It's a discretion. But these people, they say, if you refuse to step aside, you must be suspended. In fact, in terms of 2570, which, as I said earlier in the day, is just a misnomer. There is no world where 2570 can be aligned to an instruction of that you must do something, because the delegates of the National Conference decided to use the word may, and we have to assume that they were awake upstairs when they used that word. They knew exactly that they wanted this there must be situations where even if you are charged, if the SG thinks that it's not in the interest of the ANC, you should not be suspended. That's what the delegates were saying. They were saying there's no such thing as a mechanical thing. You are charged of some traffic offense and then you must be suspended. Because it would be silly for the delegates to gather there to make a rule like that, to say as long as you are charged of any offense in the world, you must be suspended. The reason they used the word may was so that those but now these people have re-engineered, repurposed it to say it's a must. I'm sorry, justices. I know, it's the politics of the day might people might think, okay, look, we're all fed up with corruption and so on, but this is not what this case is about. This case, your duty with respect is simply to apply the law blindly. It doesn't matter who is involved, but imagine that anybody was before you and saying, my right to participate in the organization of my choice in terms of section 19(1)(b) have been taken in the manner that I have described to you today. There is no court of justice, at least, that can say that, no, let's find a way, well, maybe when they say must, they really mean may, it can't, it's not possible. It's not humanly possible to find that this suspension was lawful. Firstly, because of the instruments that were used to do it, which we have discussed, because of the manner in which it was done, because of the flip-flopping on the part of the ANC. Today you are in, today you're out, now you must sign this, authorize this, no, you are suspended, retrospective. I mean, it's a mess. And then to crown it all, you then come and say that let's now re-engineer not only the step-aside rule, let's also re-engineer 2570 and change it into a rule that where the NWC must have satisfaction, whatever that means. I don't even know how that works.
Okay, good, Mr. Mpofu. I think we've tried not to interrupt you, and I think that's good. And I think that sort of brings you to the end of your argument. And I want to just leave 5 minutes for any questions that there might be.
Well, Mr. Mpofu, if I could just come in terms of the last point that you made. I see you emphasizing on the discretion to be exercised by the SG to suspend, the may suspend. But when I read that clause, it also says that suspend assisted by the NEC, the NWC, the PEC, or the PWC. Is that not also an important factor to consider in determining whether the powers they were exercised appropriately?
Yes, no, it is, Justice. It certainly is. Except that that's not what the rule says. The rule says, let's go to SG 7, which is where the actual suspension letter. It's quoted there in full.
Yes, I'm there.
Yes, thank you. Where a public representative has been indicted to appear in a court of law on any charge, the Secretary General or Provincial Secretary, acting on the authority of the NEC, the NWC, or PWC, if satisfied, that the temporary suspension of such public representative and so on, even the other side accepts that the satisfaction is that of the Secretary General. But the the authority. Firstly, you know that our point is that there was no authority from the NEC. But I'm being kind. I'm saying let's assume the authority point was good. Then it would mean that in this instance, the NEC, the NWC, gave authority to itself. In other words, it gave authority, and then it was also satisfied. That's what the letter really says, which makes the point even worse than what I argued, because it can't authorize itself, the NWC, with the greatest respect. But the satisfaction point is clearly, and that is why Ms. Duarte, with all the due respect to her, suddenly in her affidavit, she tries to get out of this trap, because I'm sure her lawyers pointed it out. She now says the NWC was satisfied, and so was I. We were satisfied. I mean, that's the biggest fabrication ever.
No,
unfortunately, the letter speaks for itself, because the letter says.
Mr. Mpofu, thank you very much. You've made the point. You've clarified the point.
Thank you, Justice Mulathei. If I promise you, I won't go further. If I'll just take you to the third paragraph on 001-81, I won't read it. It makes the point that I'm making, where the word "it" is satisfied.
Okay. Okay. Thank you, Judge Weiner. Anything from your side?
No, thank you.
Good. Thank you, Mr. Mpofu. We've managed to actually finish before 4:30. So at this point, we'll adjourn until tomorrow morning at 9 o'clock. We'll allow you 45 minutes to wind up the argument for the applicants, and then Mr. Trengrove may start. And we obviously, as a matter of principle, would want to give him equal time, but he would indicate to us when he starts, having heard Ms. Cello as well, how much of time he may need, and we'll leave some time for reply so that we can conclude the arguments by tomorrow afternoon. Okay, thank you then.
We're indebted to the court. The court, please.
If there's nothing else, then the court will adjourn until 9 o'clock tomorrow. I'm told that you can link up tomorrow on the same link that was used today. Okay.
As a court.
Good. Thank you.
Thank you. Bye-bye, everyone.
Bye.
Thank you.
And the court, please.
As the court pleases.
As the court pleases.